Okay, so thank you so much for joining us for today's webinar, Disaster Management Law 101. My name's Carly Hanson and I'm one of the Sector Sustainability Coordinators at Community Legal Centres Queensland. I'd firstly like to acknowledge the traditional owners of the land on which we're holding today's webinar. In Meanjin, Brisbane, they are the Turrbal and the Yagara people. I wish to pay my deep respects to elders, past and present, and acknowledge that we are on stolen lands and that sovereignty was never ceded. As today's webinar is being viewed by people throughout Queensland and also across Australia, I'd also like to pay my deep respects to the traditional owners throughout this country and extend a very warm welcome to any First Nations people who are listening in to the session today. So in a moment, I will hand over to our excellent speaker, Monica Taylor, who's the project coordinator of our Climate Resilience project here at Community Legal Centres Queensland. But firstly, just a little bit of housekeeping. So today's webinar is being recorded and I'll have the recording available for you to download later today or tomorrow. The PowerPoints have been emailed out to everyone who registered just prior to this session, and you can also download those from our website and from the handouts section on the GoToWebinar control panel. We encourage you to ask questions. Simply type your question into the question box and we'll read that out at the end of the session. We won't have too much time, so if you do have anything burning, please do get that into the question box. There is also a poll, so Monica will be running a poll early on just to test your knowledge. So we'd appreciate you completing that poll. So just a little bit about the session before I do hand over to Monica. So disaster management law is an area of increasing focus for community legal centres and for the legal assistance sector, as it increasingly responds to legal issues across all aspects of the disaster cycle. So in today's webinar, Monica will provide an overview of Queensland disaster management law and arrangements. So I will now hand over to Monica without any further ado. Thanks so much.
Thanks very much, Carly, and a very warm welcome to everybody on the line. Thank you very much for taking up your time to devote an hour to Disaster Management Law 101. I too want to begin by acknowledging and paying my respect to First Nations peoples here in Brisbane, the Turrbal and Yagara people, and to thank them for their ongoing custodianship and care for country, and pay my respects to elders past, present, and to all future leaders. And I do want to call out that respect also to any First Nations people joining us on the line, wherever you are calling in from, because I know that we've got attendees not just from Queensland, but from around the state and country as well. Just a general disclaimer as we kick things off. The information I'm going to move through this morning is of a general nature. Obviously, it's not a substitute for legal advice and it represents the law as it currently is reflected today. But we know that laws change regularly and so it may not be relevant in the near future. Community Legal Centres Queensland is really pleased to be able to deliver this piece of work. We are funded currently through a joint grant by the Queensland Reconstruction Authority and the Commonwealth Government. So we'd just like to acknowledge our funders that are making this, this presentation possible. All right, so what I hope to do this morning is provide an overview of Queensland disaster management law and arrangements. So the acronym QDMA is often used when referring to the suite of law, policy and arrangements that really guide the governance for disasters in this state. It's pretty content heavy. And the bulk of the presentation will be focused on the law and those associated materials. But later on in the session, I want to also just flag some major reform pieces that are in the pipeline for Queensland's disaster management system. And towards the end, hopefully I'll be able to just step you through very briefly the concept of shared responsibility. And we'll talk very briefly about the notion of disaster justice and human rights. It is, I think, also useful to just place this work in the context of the broader climate movement that we are in and climate justice considerations. We are absolutely living through a climate crisis, and the severity, scale, and increasing frequency of disasters is a result of anthropogenic climate change. So in terms of terminology, disaster management law still really speaks of natural disasters, but this project really in line with the climate justice movement and calls in academic and activist circles really to name those disasters as being as a result of increasing climate change caused by human activity. So my preference is to use the term climate disaster, not natural disaster. So if you hear that throughout the presentation, that's the reason why. Okay, so we're going to test everybody's knowledge at the moment. Carly's going to put up a poll, and I'd appreciate it if you could just please answer this one very basic question.
Okay, so hopefully that's showing on your screen. So how would you rate your knowledge of disaster management law from low to awesome? So seeing those responses come through. So I'll just give you another 5 to 10 seconds to get that in so that we can see where you're up to at the moment.
Thank you, Carly. And look, I'm really hoping people are going to say they don't know much about Queensland disaster management law. And this presentation is very much pitched at that sort of entry level. So let's see what the results say. Okay, so if people can see that on the screen, yeah, we've got introductory knowledge and maybe some people who do have some pretty good understanding. Fantastic. I'd encourage people to share comments towards the end of the session when we can get to them. If you have other stuff that you wish to share with the audience, noting, of course, that the way in which we deliver these webinars is pretty one-way communication, but we'll do what we can there. Okay, so let's get into it and think first about Queensland and our incredibly complex and beautiful natural environment. Queensland is said to be more than twice as likely as any state or territory in Australia to face disasters, and that is really as a result of the unique landscape that we have. We have a really beautiful long coastline, almost 7,000 kilometres, and we have very diverse climatic zones, tropical and subtropical, but out through to hot, arid and warm temperate climates, depending on the different regions. The Great Dividing Range creates very different climatic situations and landscapes, whether you're on the east and west side, and high energy landscapes are really likely to generate rapid and destructive rainfall. When you add climate change as an overlay to our geography, it's bringing with it new and intense weather patterns. Queensland's just had its warmest June on record since 1910. And as we move into the next few years, we can absolutely expect particular driving features. So we will have fewer but more intense cyclones. And that's going to be combined with increased rainfall and higher storm surges. The likelihood of dangerous bushfire weather in Queensland has already doubled over the past decade. We've already experienced recent severe bushfires, and with the El Nino alert currently issued for Australia for the coming summer period, bushfire risk is absolutely something that I think we can anticipate. Alongside bushfires, or what often precedes bushfires, are those hot, dry conditions that can culminate in heat waves, and there are heat wave projections likely to increase right across Queensland, but particularly for people in the far north and western regions. So climate change is driving the compounding and cascading nature of disasters, And it's for that reason that I think it's very important that disaster management law is at least at an introductory level understood by our sector. I've added this graphic at the beginning because I think it's a very helpful depiction of the disaster cycle here in Queensland. The circle that you can see, it comes from the State Disaster Management Plan. It is a timescale representation month by month of extreme weather events. And it's really broken into low risk and high risk periods. So if you find the month we're in at the moment, July down the bottom there, not much is going on, right? You can see that all of the extreme weather events will really come to us in the higher risk period, which is the tail end of a spring right through summer and a little bit into autumn. Interestingly, though, bushfire season has already started. So bushfire season is getting longer. The other thing that this graph I think is helpful in our understanding is that it breaks into the different phases of the disaster cycle, which I'm going to speak a bit more about in more detail in a second. But you can see prevention, preparedness, response and recovery colour-coded as you go around the calendar year. All the various hazards in Queensland have been risk assessed, and the most 7 significant ones are listed there in order of priority. So tropical cyclones and riverine flooding are still our joint highest priority, but as you go down, you can see heat waves, for example, equal third with coastal inundation, and they rate a greater hazard than bushfire, and that is most likely as a result of the increasing mortality rates that heat waves bring with them. Okay, so let's start with the basic legal framework. In Queensland, we have the Disaster Management Act, and this is really the key piece of legislation that outlines how disasters are governed across the state. It was introduced by the Beattie government in 2003, and at the time it replaced a pretty outdated piece of law called the State Counter Disaster Organisation Act. And that had been in operation for 28 years. So it was well due, we were well due for a modernised approach to how we manage and coordinate disasters. Obviously, there are accompanying regulations as well. So the Disaster Management Regs of 2014 work alongside this legislation. I haven't provided any slide information about the regulations, but just so you know that that they operate there as well. And the main objects of the legislation are achieved, it's listed here in section 4. And under the legislation, disaster management groups are established at various tiered levels, local, district and state levels. The legislation requires the preparation of disaster management plans and guidelines. It sets out how disaster situations are declared in Queensland, and it establishes the Office of the Inspector General Emergency Management, otherwise known as IGEM. IGEM is really the main administrative organisation that conducts a variety of functions to support disaster governance in Queensland. So a lot of regular reviews and assessments of the State Disaster Management Plan to make sure it's working effectively. And it also conducts assessments and reports on the performance of entities that are responsible for disaster management across the state. All right, so how is a disaster defined in Queensland? This definition is located in the early part of the legislation. A disaster is a serious disruption in a community caused by the impact of an event that requires significant coordinated response by the state and other entities to help the community recover from the disruption. Serious disruption is further defined, and this definition is repeated throughout the legislation. It means loss of human life, illness or injury to humans, widespread or severe property damage or loss, and widespread or severe damage to the environment. If you look at what an event means, according to the legislation, it is a really broad definition. And so it relates to events that are both natural or caused by human acts or emissions. So in terms of the legal work that people do to respond to issues arising from disasters, we tend to think of that in terms of 1A, all of those events that I briefly mentioned before. But the disaster management legislation is much broader than that. So events that could relate to, for example, an oil spill in the Great Barrier Reef, COVID-19 as an infestation or epidemic, plague, for example, and terrorism attacks as well. It is pretty all-encompassing. It's useful, I think, to pause and think about, is it a disaster or is it an incident? Because we have emergency incidents that happen all the time on a daily basis at a local level. You can see an illustration here of a multi-vehicle accident on a highway. But disasters are not just incidents. Incidents do have a level of disruption, but they will not affect a community's ability to function in the same way that a disaster does. Incidents are able to be managed by responding agencies using their own resources or with minimal assistance with outside agencies, but disasters really require that multi-coordinated approach. It's useful to recognise as well that in addition to disaster management law, Queensland has a whole lot of legislation that prescribes powers and emergency declarations across agencies. So whether it is a disaster or an emergency is declared through the Public Safety Preservation Act, police will always have a really lead role, and police powers are enlivened in the declaration of a disaster situation, really as of right. Other legislation, though, comes into play depending on the nature of the event. And we saw that through COVID-19 with the Public Health Act and the public health directives that were made emanating from that legislation. Different agencies, Queensland Fire and Emergency Service, for example, really do the lead agency work in terms of bushfires, and they have dedicated legislation for that. Biosecurity, things that involve diseases from plants, animals and pests. And when we have an international border with Papua New Guinea, biosecurity is a disaster event that is particular to Queensland, given our geography. Also, it's useful, I think, to realise that there is national legislation at play as well. The National Emergency Declaration Act is a new piece of law that was implemented in response to a recommendation of the Royal Commission into Natural Disaster Arrangements, the Bushfire Royal Commission. The first use of the Commonwealth powers under that legislation was when the Morrison government declared the flood emergency in Lismore was a national emergency in March of last year. So importantly, under that national legislation, it is possible for a declaration to be made by the Commonwealth without there being a request from a state or territory or state premier. But the Royal Commission was very clear in its findings that states and territories still do have primary responsibility for the protection of life, property, environment in their jurisdictions. And so they really exercised some caution in their findings that they do not want that power to be supplanted by the Commonwealth. Okay, just moving through to the guiding principles of the legislation. A comprehensive approach is what the 4-stage planning is referred to. So you'll see there prevention, preparedness, response and recovery, PPRR. that is really the guiding framework for how we do respond, manage and govern disasters. All events in Queensland are required to be managed in accordance with high-level policy documentation. So we have strategic policy statements, the State Disaster Management Plan and Disaster Management Guidelines. One really distinctive part of Queensland's legislation is the primacy given to local governments for managing events in their local area. They are given legislative support by district and state groups when required or requested. So appropriate resources and support can be delivered to local governments if the disaster is bigger than they are able to handle themselves. But really, locating the primary role for local governments recognises the importance of that local response and place-based knowledge as well, given that people, when the disaster happens, and we've seen this with the floods and the bushfires, it's our neighbours, it's our local community groups, it's our neighbourhood centres that really take that initial first lead. Okay, now this is an illustration to make it easy for us all to conceptualise visually the Queensland disaster management structure. You can see right at the top, we have at the top of the triangle the local disaster management group and coordination centre, and this is a 4-tiered approach that progressively escalates. So we start with local, and then we move down into district at the district level, and then into a state level. The brown part of the triangle is the State Management Committee. Obviously, district is an extra layer to existing governance structures, and in the disaster management space, they're often referred to as the middle managers, and they perform that middle management function. The groups are typically chaired and coordinated by Queensland Police, whereas at the local level, it is a mayor or an elected councillor who steers the local management group. But we have 77 local government areas in Queensland. Each of those areas will have a local disaster management group, and they are folded into 23 districts as you sort of move down the triangle. When we get to the state level, that is where the Premier chairs the State Disaster Management Committee, and various ministers and directors general from various portfolios will fold into that committee structure, depending on the nature of the event that is being addressed. Supporting and underpinning those disaster operations is, as I sort of mentioned briefly just before, a wealth of policy frameworks. There's not scope to go into this information in any detail, but I just want to flag that this doctrine, as it is referred to in disaster management, exists and is publicly available either on the IGEM website or the Queensland Disaster Governance information pages. All right, we're now going to move and just change pace slightly to move into the meatier parts of disaster management law existing under the legislation. So before we talk about disaster declarations, it's important to mention that the disaster management system in Queensland is quite capable of dealing with events in most cases without actually having a disaster situation officially declared under law. When that does happen, though, it happens under this legislation, but emergency declarations can also be declared under the other laws that I referred to earlier. It is possible to have a disaster situation declared under the Disaster Management Act and at the same time an emergency situation having been declared under the Public Safety Preservation Act. And those two pieces of legislation explicitly complement one another in that regard. Even though local governments are given primacy in local disaster coordination, they do not have legal power to declare a disaster. That power is reserved for, at the district level, the district disaster coordinator, usually that senior police officer in the service in the area, to do so with the approval of the minister. And for a state level disaster, the minister and the premier are able to make that declaration. Disaster situations are in the official legal declaration is in force for 14 days under the legislation until, unless it ends sooner than that or until it's extended by regulation. And there are sections that prescribe how disasters are able to be extended. The significance of having a disaster situation declared is that additional powers are authorised and granted to nominated officers. So you can see here a list of who gets the ability to exercise declared disaster powers in Queensland once a disaster situation is live. And that includes ambulance officers, fire officers, health officers, and other people that are deemed to have sufficient expertise and experience. The police automatically are able to exercise disaster powers. And they're pretty significant. The powers are extensive. You can see here a summary of Section 77 powers, and they vary from controlling the movement of people, animals, vehicles, to conducting evacuations, being able to enter places without warrant or consent, containing materials, disconnecting utilities, shutting down roads, and through to dismantling, demolishing vehicles and structures. In addition to those general disaster powers, the legislation has powers to give directions about property, including residential businesses and residential premises and businesses, and it is an offence to fail to comply with the direction unless you have a reasonable excuse for doing so. There are also rescue powers prescribed in the disaster management legislation. And so they include powers to enter a place, to use reasonable force, and to exercise those general disaster powers when you are rescuing people. I just want to note at this point that there's some really interesting research that's being done by our friends at Hopwood Ganam about the liability of people who undertake to rescue their neighbours, but in a civilian capacity when they haven't been authorised to do so, to be given that power under law. And hopefully we'll be able to share that research as part of this project further down the track towards the end of the year. The protection from liability is contained in the disaster management legislation for people who are authorised to exercise disaster powers and rescue powers. So protection covers Queensland itself, local governments, the minister or any officials for anything they have done or failed to do in pursuance of the powers under this Act. Importantly, given that the SES is comprised mainly of volunteers, there is provision for work cover insurance for people who are required to give help under these powers. And so if anybody sustains personal injury while they're performing their functions, then work cover will come into play so that they can receive that insurance and protection. All right, now just this slide very briefly takes you through the offence provisions. It is unlawful to impersonate an authorised person. So if you are a person who is authorised to exercise disaster or rescue powers, it's an offence to obstruct them from doing their job. to fail to comply with those directions or fail to help particular persons unless there is a reasonable excuse. And it is a penalty provision, so the maximum penalty unit is 100. All right, now we're sort of moving towards the end of the sort of the meat in the disaster management law, but what I wanted to just quickly flag before we close it off is the provision for compensation, because although there is no there's no liability, there's complete protection for liability for people who go and exercise disaster powers. Somebody who does suffer loss and damage because of those powers is entitled to seek compensation for that loss or damage. These provisions of the legislation are quite far down in sections 119 and 120. Compensation is not payable, though, if the loss or damage is already covered by a policy of insurance, the conduct of the person would have contributed to that loss or damage, or it would have happened in any event irrespective of the exercise of the power. The compensation process is outlined here for you. There's a what I think is fairly limited time period to seek that compensation. I mean, it's 90 days, but often in the context of trauma-informed practice, we know that it takes people a lot longer to get themselves ready to take that kind of action. The application needs to be particularised. It needs to detail what the loss and damage was, how much compensation you're seeking and how you reached that dollar value, and any other relevant information. You can submit an out-of-time application and it'll be considered. The Chief Executive needs to determine your request for compensation within 2 months, 60 days. And written reasons need to be provided, and it's a reviewable decision. So you can go to QCAT for a review if you're dissatisfied with the outcome. There's some case law on compensation, and we all remember the horrendous floods in 2011. This case law comes from the Lockyer Valley, where those floods ripped through the local area and caused serious damage and loss of human life to the town. The local pub, the Murphy's Creek Tavern, was one of the only 2 buildings that escaped serious inundation during that flood event. And so the community set up their recovery operations pretty much immediately from the tavern. And then it brought in all of the associated agencies to deliver emergency evacuation and responses. So QPS, Fire and Emergency Services, Department of Communities, everybody located in the tavern to conduct their disaster operations. So what happened was the publicans, after the event, had a negotiated payment given to them with the Department of Communities for the cost of using their premises, using their power, sewerage, food, accommodation in relation to the disaster operations. So that was a $14,000 settlement. But then much later, a year and a half down the track, the pub owners initiated proceedings. So they started seeking compensation outside the disaster management compensation provisions. They went to the district and then Supreme Court and were rejected. The claims were dismissed. Then they circled back and sought compensation under these provisions in the legislation. So they were held to be out of time, well out of time. It was, you recall, it's 90 days. So that was, that's sort of what killed it off. But importantly, the tribunal also did make a clear determination that they hadn't ever linked the claim for compensation to the exercise of a general disaster or rescue power that had been exercised and asked for them to do that recovery operation. The tribunal held that it was the community themselves that had set up the operation, and that generosity and community goodwill doesn't result in a right to compensation. I think that's a pretty sound determination by QCAT. But what I think it does bring up in terms of the broader complexity of disaster operations is the concept of a shared responsibility. So this is a really key governing principle that informs how disasters are to be risk reduced and managed. The principle itself doesn't appear in the disaster management legislation. So if you keyword search shared responsibility, you will not find it in our law, but it is certainly embedded throughout the policy documents that underpin the legal arrangements. And it comes down from the United Nations Sendai framework for disaster risk reduction and has filtered into national strategies as well. The concept, the idea that we share responsibility for disasters when it works well is really fantastic. It's very aspirational that we all have distributed and really clear roles to play in disaster. We say that it's not just government that comes in and does the job, but that communities really have agency to determine for themselves what they need in a disaster. The problem, though, with anything that is pretty amorphous and ill-defined is that it can be very susceptible to being politicised. And so finger-pointing can happen when government doesn't step up or community feels that government has overburdened their response and not listened to their needs in disaster response and recovery. Other criticisms of shared responsibility are that it is a pretty neoliberal construct, and so it really places responsibility on individuals to generate their own outcomes. Shared responsibility is very much here to stay. The Royal Commission acknowledged and in very positive terms the notion of shared responsibility. I think the obligation, certainly on communities, is to really say what it is that we need in terms of exercising our own agency for shared responsibility and really calling out when we feel that there has been a lack of a lack of government support when needed. All right, so changing track now. I'll just take a pause and a sip of my water. And congratulations, everybody. We have made it through Disaster Management Law 101, at least the legislation itself. Having presented to you all the ins and outs of the legislation, though, I now need to flag with you that there is a significant reform piece underway to modernise the system of disaster management in Queensland. So a couple of years ago, the Queensland Government commissioned an independent review into the Queensland Fire and Emergency Service, the QFES being the entity that is responsible for being the chief executive under the Disaster Management Act. KPMG's report recommended that the Queensland Police Service assume the functions for the SES and disaster management coordination in Queensland away from QFES, and that the Commissioner of Police becomes the chief executive rather than that responsibility staying with QFES. Those recommendations have all been accepted, bar one. I hear you ask, what is the one recommendation that the government refused? It was a levy to raise funds which would have actually funded the SES to the tune of $120 million a year. That was not accepted by government. So what that means is that the Queensland Police Service is going to take an even greater role in disaster management operations. It already has a very significant role. One of the rationale for this reform piece was really to harmonise the exercise of the legislative basis for the authority, because in practice, although QFES administers the legislation, the operational responses to disasters, with the exception of bushfires, is really coordinated by other agencies. And it will also lead to the Queensland Fire and Emergency Service having a more targeted fire function, and they anticipate that a new fire department is going to be established. So that is really a heads up to say that this boat has really already sailed. There's already work being done to streamline this authority and power, and there is likely to be an opportunity down the track for public consultation into the review of not just the Disaster Management Act, but probably also Fire and Emergency Services legislation as well. This little snip is from the Queensland Police Service website, just indicating that that the reform piece is well and truly on foot. Okay, so knowing what we know about the extremely detailed and prescriptive coordination of disasters in Queensland, I want to, in closing, because we don't have too much time left, just turn to a more reflective space and talk about the concept of disaster justice. So much like climate justice, we know, and certainly people working in community legal centres know, that disasters do not impact everybody equally, and that they expose existing injustice and inequality in society. There's increasing critique about the way in which disasters are handled, and the more savvy we get at conceptualising disasters as part of the everyday response of community legal centres in terms of the legal services that we deliver, the more we will be able to think in terms of seeking disaster justice for our clients and our communities. The risk of injustice happens at all stages of the disaster cycle, not just in the response phase, but some examples might across the cycle might look a little bit like this. And I have just put these down based on actual experiences that have happened either in Australia or overseas, and anecdotally stuff that has come to the fore in recent times. So in disaster prevention, when we make decisions to zone public facilities like prisons, youth detention facilities, inpatient mental health centres in flood-prone areas, of course, that is, laying the groundwork for disaster injustice. In preparation, when we design evacuation procedures that might fail to account for accessibility requirements for people with disability, that is a disaster injustice. When local recovery centres discriminate against certain cohorts of people, then we can see injustice playing out in that immediate response phase. And in the long tail of disaster recovery, the way in which we design our disaster recovery schemes and our emergency relief payments can result in injustice if those schemes do not equitably support the people who need the help the most. Obviously, human rights as a vehicle for seeking disaster justice is really available to us here in Queensland. We're so lucky to have the Human Rights Act and the enumerated rights that I've just popped down there on the screen really come into play at every stage of disaster. I would like to acknowledge the work of Bill Mitchell from Townsville Community Law, who has really led a lot of thinking around protecting human rights in disasters. If you want a little shortcut for how you might want to frame up a human rights complaint relating to disasters, then I recommend you go and read Bill's Proctor article that was published a couple of years ago, and also Townsville Community Law's really terrific disaster legal needs work also goes into a lot of detail about the international standards that can guide states in ensuring disaster management is both human rights respecting and leaves no one behind. Yeah, even though the Sendai framework for disaster risk reduction is reflected in our national strategies and here in Queensland as well, there's still a lot of work to be done to explicitly integrate the Human Rights Act into those state-based frameworks. So thank you, Bill, for your work in this space, and I really hope that this presentation has also helped people just get the lay of the land when it comes to disaster management. The last thing I wanted to mention before we wrap up and invite questions and comments is that as part of this piece of work, Community Legal Centres Queensland is really wanting to prompt discussion with our members about disaster and climate justice. And as part of the way we want to do that, we're creating a space in the calendar in the last Wednesday of every month for an hour as a drop-in space to come and talk about how climate change and extreme weather events might be playing out in your work and potentially for you personally. And that's an hour where we can have a bit of a chat, and we can also communicate back to members some relevant updates and climate action news. So that actually falls on tomorrow afternoon. And if you are interested in coming along, then you can complete the closing poll, which has an opportunity for you to leave your name and email details. All right, so thank you, everybody. That's a wrap, and I'll just go pass back to Carly to see if we have any comments or questions.
Thanks, Monica, and heaps of time for questions. So please do pop those into the question box if you've got anything that you'd like to know about disaster management law here in Queensland. Just while you're doing that, a couple of questions have come through. So Kath is wondering whether you foresee any issues with vulnerable people and communities being over-policed during disasters, and how that links in with the allocation to other agencies for emergency responses.
Thanks, Kath, for your question. Yes, I do. I mean, I was surprised to learn of the reform implementations and the shifting and transition of power across to police. I think it is something that we need to be really mindful of. Interestingly, one of the reasons for the change piece was a recognition that there were some cultural challenges, including gender imbalance within the Queensland Fire and Emergency Service, and a lack of diversity as well. But I note that that's those kind of critiques have also really come to the Queensland Police Service in recent years as well. So I think it is upon us to really be aware of that change and to be ready to shine a light on it if and when that happens. I mean, having said that, Queensland Police are deployed in all disaster situations and play. Without the police, we would not be able to cope with the level and severity and scale of those events. So. We need to be able to kind of walk that line and not be overly simplistic about our concerns with Queensland Police, but knowing what we do about operationally how those powers can be exercised. I think it's wise for us to be just a little cautious.
Great, thank you for that. Maeve has asked, is the reform of disaster management in Queensland limited to the findings and recommendations of the KPMG report, or have other reforms also been flagged?
I don't really, they're unfolding at the moment. So I think they will be, they're likely to include the KPMG findings in addition to some other findings and recommendations, because the iGEM report that came after the KPMG report had additional recommendations within it. So the information is not completely out there in the public realm about the full scale of the reform process. So I think it's a watch this space sort of answer for you, Maeve.
Great, thank you, and thanks for the question. And we'll keep an eye on that one. Just wondering also where we might be able to find information about future public consultation in the emergency response reforms.
I would do what we probably all do, is just sort of scan for that information. Certainly Community Legal Centres Queensland can distribute information when we are aware of it, but we don't know anything that other people don't know at this stage. So I think it's a matter of subscribing to updates, monitoring those developments and circulating. And we will do, our job to sort of circulate it throughout our sector as well.
Okay, great. So there is time for a couple more questions, and just while you're typing those out, I'll just remind you, so at the end of the session, there will be our normal evaluation survey that will pop up for you, and it has those additional questions so that if you want to be part of our ongoing work, if you're a CLC worker in Queensland, and come along to that information exchange or community of practice that's happening tomorrow afternoon, please put your name in there. Or you can send an email to Monica or to our team here at CLCQ, and we will make sure that you get that invite out. So it looks like no other questions coming through at this stage. Monica, is there any last thoughts that you had, or anything else that you wanted to flag in terms of the project work that we're doing here at CLCQ, or future sessions that are coming up in this area?
The only thing I would like to flag is that the work of disaster resilience and capacity building is very much something that happens best when it's done together in community, and so very much a process of co-creation. I don't presume to have any of the answers for the complex challenges that lie ahead for us in terms of disaster coordination, and so I think very much putting our heads together to think through ways that we can ensure that disasters are responded to at the same time as human rights are respected and people are not left behind is really important. So just really encourage conversation and dialogue with one another as we move forward.
Excellent. Well, we might wrap up the webinar session for today, but I will do a quick plug for an upcoming webinar around disasters that we have coming up on the 9th of August with Dr. Kate Brady from the University of Melbourne and the Australian Red Cross. So that one will be coming out to you soon with a link to register, but it is also already on our website, and it's around supporting communities affected by disaster, insights, challenges and tips. So keep an eye on that one. Thank you so much, Monica, for presenting today and giving us a really comprehensive whirlwind tour of Disaster Management Law 101. Hopefully that's been helpful to everyone in the audience, and thank you for your engagement in the poll and the questions that you've asked, which were really great. As I said, just pop your responses into that feedback survey, and we hope to see you at our future webinars in this area and elsewhere, and hopefully also in the disaster management or climate resilience exchange that's happening on the last Wednesday of every month. Thanks so much, everyone. Bye for now, and have a great day.